So now we have our presentation completed. I can just insert we have no Q&A here. So now I will turn to the audience and ask if you have any questions for our amazing speakers. Yes, please.
Question with sort of looking for a reaction on transaction costs. Kind of, well, within the DAO, it's quite interesting. You look at a lot of DAOs and we have market-like behavior internally. So if they're operating by putting bounces on tasks, they're taking on that transaction cost that's normally there in the market and having to price every task. Sure, you mitigate that by retrospective approval, things like that. But I suppose you can show you're explaining retrospective rewards with causes.
Yeah, but it's interesting. I also thought of that being an hybrid between the price mechanism and the firm.
Yeah.
Price in the middle, and
Yeah, I guess sorry, my thought or question is, of all the different kinds of transaction costs, so it's things like, legal enforcement, sure, that drops away if you've got guaranteed execution, smart contract, but how does that constrain what a DAO can be? Because they're talking about very narrow definition DAO, it's just doing atomic exchanges of crypto assets. Rather than somebody actually doing something which they might fail to do, then we're back to dispute resolution. How do we resolve that? Sorry, I'm more interested to chat about it than actually know. No, it's we can do that.
And also, this was a simple idea. And to go to it, even through all the transaction sources, I think it's a difficult task because also DAOs are very diverse. So even a legal qualification of DAO must be very flexible in this regard, and also taking account the different transaction stocks, we cannot do very narrow analysis. But yes, this is my presentation without some limitation to go further. It's not something.
Yes, I have a very practical question. Considering, again, right now the crisis situation with migrants in Europe, for example, people who are coming from Eastern Europe and who have no any support or protection here, for example, people from Belarus or from Russia that are running away from dictatorship, they're going to need regulation, they need a court system, they need all these instruments, but they don't have it here. Imagine that they adopt a DAO to organize themselves and have this kind of like privileges inside their communities. How is it possible to connect those self-regulation and self-judicial system to a national court system or European? Is it like possible to make it legally?
I don't know to whom this question should be addressed, but maybe Thomas, do you have any thoughts on this, or Jamelia?
Yes, I'm very sorry because the sound is a little bit like muffled, so I'm trying to catch all of the questions. I'm going to rephrase it. I'm not sure if I heard everything correctly. Please feel free to repeat it. Was your question in regards to in case there are Russian or Belarusian citizens coming to Europe, starting a DAO and benefiting from certain regulatory frameworks in case where perhaps they wouldn't be benefiting in case that was in, I don't know. I'm just trying to grasp. Could you maybe rephrase the question again?
Yes, sure. So if those people, experts, organizing as a DAO, they have internal dispute resolution system, internal regulation, how they can connect this internal system with the external national regulation or European-wide regulation? Is it possible legally?
Yeah. So the internal regulation, or are we talking about like blockchain-based dispute resolution, how it transports to traditional like legal systems and courts, whether it's ratified, whether it's treated equally as a, traditional court decision, right?
Right.
Okay, sorry. I've turned on the maximum volume. I'm extremely sorry. So that's actually a great question, but to be honest, I don't see any difference between Russian, Belarusian, or Portuguese, or any other citizen who, for example, deals with the DAO, or they utilize blockchain-based dispute resolution system, and then they, perhaps may have questions how to ratify it. So first of all, just because it's like my topic of research, I think that this question of like ratification or equaling a blockchain-based dispute resolution decisions to like arbitration awards or traditional court decisions isn't 100% something that we should always be doing, because sometimes it actually defeats the purpose, in a sense that if we have all of our relations or like all of our transactions on chain, why would we need this, legal world ratification, one might say? Because if everything is self-enforced through smart contracts, and let's say we're talking about some, contractual agreements, and both of the party consent to have their dispute settled by such alternative dispute resolution tool, why would they then require to go further and have this additional confirmation? We had this precedent with Claris when two of the parties decided to utilize it, and then they didn't have all of their like finances, everything set on chain. So it was more of like a hybrid kind of situation where it was a tenant agreement, and nothing was set on chain. Apart from, both of the parties submitting their evidence. They actually appointed like a third-party arbitrator who then utilized Claris, but that's not really important here. Then they submitted this decision award to Mexican court, and Mexican court basically in the situation when neither of the parties disagreed with the decision or with the method for dispute resolution, then the court proceeded to, to enforce that decision through the public force. Then we can have discussion whether that court actually ratified this decision or just was okay with two of the parties contractually agreeing to having, their contract and their dispute decided that way. But this is what we already have seen. So we already have seen this connection between traditional courts and blockchain-based dispute resolution systems. So it's not something new. The case happened in 2020. Maybe if we had more cases, we could have judged it in a more, general perspective and idea. Then I'm trying to, map I have experience working with Russian lawyers and with Russian courts. And then it actually doesn't matter in the sense of whether it's Russia or any other state. It depends on how specific state treats this alternative dispute resolution system and how flexible they are to adopt, for example, cryptographic tools being used in evidence or anything else. Like in my practice, I've seen countries, for example, as United Kingdom, that is quite open to embrace those blockchain-based dispute resolution tools. In Russia, my personal take, first of all, if you are exiling from Russia today, I don't think the last thing I think you care is whether your dispute that was rendered on chain is recognized in Russia. Like, this is where I'm not getting the question. So in my opinion, in any other country, that would be very case specific, based on the local regulation, based on what parties are trying to achieve, whether they're trying to set a precedent or whether they are trying to enforce through public force because their relationship weren't on chain before. Sorry. And in the case, if two parties satisfied and they are, for example, if they're part of the DAO and they are deciding, let's say, their governance issues through the use of those tools, I actually don't see any reasons other than like curiosity or precedent setting. Why would they then seek this, a ratification? correct me if I'm wrong, and please feel free to maybe add on it. But that's my opinion. That's how I understood the question, at least.
Thank you.
Thank you so much, Emil. Are there any other questions for our speakers? Go ahead.
Yeah, mine's still certified from our state, DAO.
Yes, I do answer by the. I'm used to it, the more I could pronouncing it.
I like to create a cliche that really people are pronounce like that.
Yeah.
So I'll let it afterwards. But one of the things that I thought was quite interesting about different models that you have for how DAOs can transfer information is the construction where you have the DAO and the legal wrapper, where the legal wrapper is delegated task of operations.
Yeah.
And this causes a situation where the knowledge of the day-to-day operations isn't always with all of the DAO members, because the day-to-day operations is on this delegated body. And then on top of that, there are often cases where this legal wrapper cannot always give information about what it's doing to the DAO directly in its full capacity. Why? Because it's protected information. There are times where this might be IP, this might be patented work that doesn't necessarily need to be given out to everyone. And so there's this friction between the knowledge that the DAO needs to know all the time to have its full duties, and then the knowledge that the operator, the legal entity knows. And so there's always a level of, I wouldn't say schizophrenia, where the DAO has two heads, where it's got this head of things that it should know and then things that it doesn't know. And then that also causes a friction on a corporate level as well, not just with the principal agent, the agent principal, but also on the level of whether the operators are actually part of the DAO, right? Because you've got some jurisdictions that are saying that they're creating these legal wrappers to be the DAO. And then is it the case that the DAO is just these token holders that are delegating tasks to operating to the legal wrapper? Or is the DAO the entirety of this whole construction that you have? So, yeah, I thought it was quite interesting to bring about it.
Thank you very much for your questions. Also, position I ever saw on issues, of course. The way I see this, my first intuition when I looked at the topic, the way I looked at thousands, particularly in the case of the legal wrappers, they are acting as wrappers. Okay? That is my first intuition. So I tried to give an answer to that problem. Of course, they are not truly managers or directors, because that depends on the contractual relation established between the DAO and the wrapper. And of course, the attribution of knowledge has to be limited to the functions that the legal wrapper is truly providing for the DAO. And of course, when I said in 2 or 3 times that knowledge is always relevant in the context of an action. And that means that it's not the whole knowledge that acquired by the director of the director that is the DAO. It's only the knowledge, by principle, the knowledge that is acquired in the high performing of their duties for the DAO, and related to that, he has a duty to intervene if he knows that the DAO or the token holders are acting in some way, and if it is his function to intervene, then he has to. Of course, when we are talking about a decision that is not outsourced or transferred not technically, but when it is not before contracting with the legal reference, the management powers are powers from the owners. Okay? So concerning, we have to look completely to the contractual relation established between the DAO and the legal reference and determine which functions are sticking to the protocols. And the decisions they make without and that are which is supposed for them to make, and the knowledge is held by the legal record, and of course this knowledge is not attributable because there's not the duty to even transfer this information from the legal record to the DAO because it's falling outside the contractual obligation of the DAO. I don't know if I'm making myself clear, but and there's also, and you mentioned, of course, another topic is concerning about confidentiality. Then you have the legal limit the attribution, so you can have knowledge to things like that. And that's very common in the traditional mechanisms where we have a director of 2, 3, or 4 companies. The knowledge is to be attributed, but if it's not, if it's confidential, if it's confidential matter, then it's not attributable. And the other company cannot act based, as if it should have known. So,
there are a couple of questions. Do you have time?
I just wanted to add something.
I just wanted to add something about this question, which is very first. I think we should be very careful with this analysis. But when we talk about legal outcomes, I'm sure that it's going to be answered. So I'm not sure that I understand really your position, but I think that your term legal outcome refers to an area or something like that. And it is not necessarily something that is directly linked to the DAO. But I'm not sure that I understand very well. Because you have different situations. You have the mechanism, the LLCs, and I think they can be identified as legal reference, and people call them legal reference, and they are clearly merged with the DAO. Because the LLC is just a way to encourage the DAO in the territory of the state, and they clearly function together, and generally they are the same members. So, you have the same members in the DAO, the same members in the LLC. This is very interesting. And then you have this other model that you find, for instance, in Switzerland, when you have some DAOs that ask an association or foundation to do some business for them, to act, to send outsource some tasks to this DAO, to the association, to the contract with the people, and so on. So in this situation, you have to distinguish if there are the same people in both structures or not. This is a very problem. And if there are the same people, that's the problem. If there are different people, of course, there are different entities. One is the DAO, and the other one is a foundation, association, or one. And this corporate structure, or this entity that has a legal status, this is responsible for everything. And then, if there is a claim involved between the DAO and the association foundation, of course, there is a contract with them, if you can consider that the DAO can have a contract. So, there is a lot of risk for people who are in the foundation or association because they cannot then say, well, we have made something for you now, and now you are responsible, okay, fine, they manage responsible, because I know you are liability and you don't know our elements. So I think it's very important to say what we are talking about, because
So,
now we can also say, well, I just want an agent in the real world, so you, me, we can have presentations and contract for the DAO.
Yes.
The same problem.
Yes. But there's, you're probably correct. So I'm talking about two different entities, but there's a difference between being solely an agent and to be a company where I can outsource some services. And the main difference is that the relation established between, in the case of outsourcing, between the principal and the service provider is that the relation is much more stable. Okay, it's not to comply with an act just once or two or three times. It is a stable relation that is medium or long-term relation. And of course, it can be that we have the same persons in the DAO and in the web. That cases are cases of double mandate, I would say likely, I would say like this, where the beneficiary of knowledge is not even discussable. It is discussable in cases like you said, because of confidentiality, and where there is a legal duty to do not use this information in the other. And there's the other possibility, and the other possibility is that there are different people. So if you have different people, the knowledge is to be attributed as knowledge. And to be attributed not, because it's not just a matter of, as I look at the DAOs, acting on behalf of the DAO to comply with obligations of the DAO. Okay? So it's not a question whether the legal record as an outsourced company is responsible or contractually responsible vis-a-vis the DAO, is whether in the relation with the third party, between the DAO and the third party, the knowledge of the legal record should be disadvantages should be a disadvantage to the DAO itself. Okay? And in that case, the third party, when a third party enters into a contractual relationship or another nature, the third party doesn't know if the DAO is capable of complying by itself. It can know, but it's not recognizable whether if the DAO is complying by itself or if it's outsourcing. So the knowledge acquired by the legal record, when it's acting on behalf of the DAO itself, it is attributable to the DAO. The DAO is to be treated disadvantageously because she is considered no, and then you have to solve the problem of the contractual liability between the legal record and the DAO.
Yeah.
Because the knowledge is not just
Exactly, yeah. To have a few more entities to ask slide that you did to take into consideration what you said, with the slight difference between the wrapper where it's an outsourced company and then the wrapper that's the agent of the DAO as well, just to see how the relationship between that works when those entities are the same or when they're different, because it does start to create another level of friction that would be interesting to see, not just from the knowledge attribution level, but also corporate structuring information level too. So really interested in working really well with it.
Thank you. So I'm afraid we have to end this section. So obviously, thank you all for being part of this discussion. And in particular, thank you for all the speakers here and for discussing this interesting topics. So thank you all. And now we have the coffee break, and then we'll have the last time.